Tenant is in a really difficult spot housing-wise. There's a strict legal process landlords must follow. You can't just say, cut the power or change the locks.
That's such a crucial point. The Prevention of Illegal Eviction from an Unlawful Occupation of Land Act, we often call it the PIE Act, is really the bedrock here. Its main purpose isn't just ticking procedural boxes. It's fundamentally about stopping unlawful evictions and making sure human rights are considered in the process.
Okay, the PIE Act. Central stuff. So when we talk about balancing rights, what's the core tension the law is trying to manage here?
Well, the law is essentially trying to walk a tightrope. On one side, you have the property owner's rights, their right to manage their property, get income from it. On the other side, you have this fundamental right people have not to be made homeless without a fair and just process playing out. It recognizes tenants can be vulnerable, and it aims to ensure evictions happen lawfully with proper thought given to their situation.
Right. So let's get practical. For a landlord in South Africa, maybe they have a tenant in arrears, or perhaps there's another lease breach, and this tenant might genuinely have nowhere to go. What are the absolute non-negotiable first steps legally?
Okay, so there's a very clear path defined by law. First off, the landlord has to serve a formal written notice to vacate on the tenant. Now, how long that notice period is can vary a bit depending on the lease agreement itself, but for a standard month-to-month rental, a reasonable period is expected. Often that's around 30 days, give or take.
And it has to be written, formal, not just a chat.
Exactly. It needs to be official, setting out a clear time frame.
Okay, so that's step one. What if the tenant is still there after that notice period runs out?
Right. If the tenant hasn't moved out by the date specified on the notice, the landlord's next legal step, and this is mandatory, is to apply to court for an eviction order. That could be the magistrate's court or the high court. They absolutely cannot, under any circumstances, resort to self-help. Trying to remove the tenant themselves, moving belongings out, that's illegal. The court process is unavoidable.
Got it. So the court gets involved. What actually happens at the court hearing? What does the court look at?
This is where it gets really important, especially for potentially vulnerable tenants. The court obviously looks at the landlord's application, why they want the eviction. But crucially, the court is obligated to delve into the tenant's personal circumstances. Can they find somewhere else to live? What's their financial situation like? It's not just about the contract.
It's broader than just the lease term.
Much broader. The court has to consider what's just and equitable. They look at the potential social impact of granting the eviction. If, after weighing everything, the court decides the eviction should proceed, then they issue a formal eviction order. And that order will set another specific, reasonable date by which the tenant must leave. It's not usually immediate.
And if that court-ordered date comes and goes and the tenant is still in the property?
That's when the sheriff of the court steps in. The sheriff is the only person legally allowed to physically remove the tenant if they haven't left voluntarily by the date on the court order.
So the landlord still can't do it themselves?
No, absolutely not. Only the sheriff acting on that court order.
Wow, okay. This whole process really does highlight the protections built in. You mentioned the court considers various factors, particularly when homelessness is a real risk. Can you maybe elaborate a bit more on what key things the courts here really focus on?
Sure. Well, the tenant's financial situation is understandably a big one. Have they lost their job recently? Are they facing genuine financial hardship that's making it impossible to find another place? The court will want to see the reality of that.
Makes sense. What else do they weigh up?
They'll also look at the tenant's efforts. What steps have they actually taken to find alternative accommodation? Have they been actively looking? And, very importantly, the presence of vulnerable individuals. Are there children involved? Elderly dependents? People with disabilities living there? That weighs heavily on the court's decision and can definitely influence the timeline or conditions.
It sounds like the system really tries to shield those most at risk. What about the landlord's conduct? Does how the landlord has behaved play a role?
Oh, definitely. If a landlord has, say, implemented unreasonable rent hikes, seemingly to push the tenant out, or if they've refused point blank to even discuss a possible payment plan for arrears or engaged in harassment, that kind of conduct can weaken their case for eviction in the eyes of the court. Bad faith is frowned upon.
Right. So putting it all together, if a tenant can genuinely show the court, look, I've tried everything, I have absolutely nowhere else to live, what's a possible outcome then?
In those difficult circumstances, the court has discretion. They might postpone the eviction, giving the tenant more time, or in some cases, they might even refuse to grant the eviction order right away, pushing for a more reasonable solution to be found first. It really shows the court balancing strict legal rights with fairness and equity.
That leads to a really critical point. If
Yeah.
we reach the end of that legal road, the court order is issued, the date passes, and the tenant still hasn't found anywhere. What actually happens then? Is there a safety net?
This is where things can get complicated. But potentially, yes. The local municipality might have a role to play. If an eviction is going to result directly in homelessness, there's an argument, based on the Constitution, that the municipality may have an obligation to provide some form of emergency or temporary housing.
And can the courts actually compel the municipality to do that, order them to provide housing?
Yes, there is precedent for that. South African courts have issued orders requiring municipalities to provide temporary alternative accommodation in situations where an eviction would leave people, especially vulnerable people like children, homeless. It underlines the state's responsibility, although securing that assistance isn't always straightforward or quick.
This is such vital information. For anyone listening who might be facing eviction right now, feeling that uncertainty, what are the immediate practical things they should be doing?
Okay, first and foremost, get legal advice immediately. Don't wait. Our team here at Jonker Vorster Attorneys deals with these matters constantly. We can explain your specific rights, look at the notice you received, and guide you on the best path forward. Seriously, don't delay getting professional help.
Crucial first step. What other avenues should they explore?
The Rental Housing Tribunal is another really important resource. It's an independent body set up to handle landlord-tenant disputes. They offer mediation, which can be invaluable. Sometimes they can help negotiate a longer notice period or work out some kind of agreement with the landlord, potentially avoiding court altogether.
And what about that possibility of emergency housing we just discussed?
Yes, absolutely. If homelessness is a genuine imminent risk because of the eviction, the tenant should urgently contact their local municipality's housing department. They need to inquire about emergency housing options and any assistance programs they might have.
Are there any other direct actions a tenant could take?
Well, it's always worth trying to communicate directly with the landlord, even if relations are strained. Could a realistic payment plan be proposed if rent arrears are the issue? Could you negotiate for, say, an extra month to find a new place? Sometimes, keeping lines of communication open, being reasonable, can yield results you might not expect.
Good advice. Now let's flip it slightly. What about things landlords absolutely cannot do when trying to get a tenant out? The illegal tactics.
Right. It is completely illegal for a landlord to engage in what's often called self-help eviction. This means things like cutting off essential services, water, electricity, that's a big no-no. Also illegal, changing the locks while the tenant is still legally entitled to be there, or physically removing the tenant's belongings without a court order. The Rental Housing Act is crystal clear about prohibiting these tactics.
And if a landlord does resort to these illegal methods, what power does the tenant have?
If a landlord unlawfully cuts utilities or tries any other illegal eviction tactic, the tenant isn't powerless. They have several options. They should immediately lodge a complaint with the Rental Housing Tribunal. The tribunal can make binding rulings to stop the illegal behavior. They can also go to court on an urgent basis, get an order forcing the landlord to restore the services immediately, and stop any further unlawful actions.
Can they claim damages too?
Yes, potentially. The tenant might also have grounds to sue the landlord for damages caused by the inconvenience, hardship, and stress of these illegal actions.
So there are real consequences for landlords who step over the line. What about challenging the eviction itself in court? On what grounds can a tenant actually fight an eviction order being granted?
Absolutely. Tenants can challenge evictions. Several grounds exist. The most common is procedural irregularity. Did the landlord follow all the correct legal steps we discussed? Was the notice valid? Did they even apply for a court order? If not, that's a strong challenge. Another ground is if the eviction seems unfair or discriminatory. Is it retaliation for asserting rights? Is it based on race, gender, or some other prohibited ground? That's unlawful. And, as we've emphasized, the tenant's circumstances, particularly the lack of alternative housing and the impact on vulnerable dependents, can be presented to the court as reasons why the eviction shouldn't proceed, or at least should be delayed.
It really sounds like having legal support is almost essential to navigate this properly.
It makes a huge difference. Knowing your rights, understanding the process, and having someone advocate for you effectively in court or at the tribunal can significantly change the outcome.
Let's just circle back quickly to the rental housing tribunal. You mentioned it's for disputes. What kind of specific issues can tenants bring there?
The tribunal handles a pretty wide range of common landlord-tenant problems. Things like, yes, unlawful eviction attempts, but also disputes over deposit refunds, unfair practices like sudden huge rent hikes, failure to maintain the property, and of course the illegal disconnection of services. It's meant to be a more accessible forum than the courts for these kinds of issues.
And their rulings have teeth.
Yes, the rulings issued by the Rental Housing Tribunal are legally binding on both the landlord and the tenant. So it's a serious process with real consequences.
Okay, this has been incredibly thorough. Let's try and tackle some of those core questions head on, the ones listeners are likely asking. First, back to the main point. Can a landlord in South Africa legally evict a tenant who genuinely has nowhere else to stay?
The short answer is yes, but with very important conditions. The landlord can pursue a legal eviction, even in that scenario. However, they must use the correct legal process, culminating in a court order. And crucially, the court must consider the tenant's lack of alternative housing and their overall circumstances as part of that just and equitable assessment before granting the order. So the eviction might be granted, but potentially with a delayed date or conditions attached, or perhaps linked to action by the municipality. It's not automatic.
And what are the core protections, again, for a tenant in that very vulnerable spot?
The biggest protection is the legal process itself. The fact that it has to go through a court that is obliged to consider all relevant factors, not just the lease. Then there's the potential, though not guaranteed, for the court to involve the municipality regarding emergency accommodation. And of course, the absolute prohibition on illegal self-help tactics by the landlord.
We touched on government housing. Realistically, is there generally immediate help available for evicted tenants facing homelessness?
Look, the reality is that the availability and speed of government housing assistance varies a lot between municipalities and depends heavily on resource constraints. While the legal framework acknowledges the need, and courts can order municipalities to act, you shouldn't assume there's an immediate, readily available emergency shelter waiting in every case. It's something tenants need to actively pursue with their municipality, but it can be challenging.
And the timeline for this whole eviction process, is it quick?
Usually not, no, especially if it's contested. The legal process involves notice periods, court applications, potential hearings, and judicial consideration. It builds in time. It can take several months, sometimes longer, depending on the court rules and the complexity. It's rarely a rapid affair.
And one final time for absolute clarity. Landlord takes matters into their own hands, physically removes tenant without court order.
Absolutely illegal, full stop. That's spoliation, an unlawful eviction, and the tenant has immediate legal recourse.
Okay, so for our listeners, especially those maybe facing this daunting situation right now, worried about having nowhere to go, what's the single most important takeaway from our perspective here at Jonker Vorster Attorneys?
Act fast. Don't bury your head in the sand. Get legal advice the moment you receive a notice or feel eviction is looming. Understand your rights, understand the process, explore all your options negotiating the tribunal, the municipality. Early, informed action is genuinely your best defense in navigating this very difficult situation.
And let's quickly recap those key protections one last time.
Right. Remember, a court order is essential for a legal eviction. The court must consider your personal circumstances, especially housing availability. Landlords cannot legally cut off water or electricity to force you out. And you absolutely have the right to challenge an eviction if the proper procedures weren't followed or if it's unfair.
And if you, listening now, are facing an eviction, or maybe you're a landlord with questions, or you have any concerns about your rights and obligations under South African property law, please don't hesitate to get in touch with us here at Jonker Vorster Attorneys. Our team has deep experience in this area, and we're here to provide the expert legal guidance needed for these often complex and stressful situations.
We really hope this deep dive into the complexities of tenant eviction, especially that difficult scenario where alternative housing is scarce, has been informative and, well, helpful for you.
Understanding the legal landscape and your rights within it truly is the critical first step.
Here at Jonker Vorster Attorneys, we remain committed to offering that clarity and expert support across all areas of property law.
So if you need assistance with an eviction matter or any other property law query, please do reach out. We're ready to help.
Thank you for tuning in to the Courtroom Club. We look forward to our next discussion.